Hello and good evening everyone. Welcome back to another video with Legal Darpan, where we dive deep into significant legal developments and explore their impact on society. This is your host Sushila, and today we are going to discuss the landmark case of Mokatlal versus Kailash Chand. This case is a fascinating study of property law in India and how the judiciary interprets the inheritance rights. So grab your notebooks and let's explore the intricacies of this landmark judgment. The Supreme Court has recently ruled on the criteria required for female Hindu to claim absolute ownership of an undivided property of a Hindu undivided family, HUF. The bench, comprising Justice B.R. Gavai and Sandeep Mehta, clarified that under Section 14, Subclause 1 of Hindu Succession Act 1956, a female Hindu must be in possession of the property and must have acquired it through specified means such as inheritance, partition or gift. In the case at hand, the adopted son of a widow claimed partition of Hindu undivided family property or an HUF property, arguing that his mother had inherited it after her husband's death. However, the mother was never in possession of the property and her suit to claim and possession was previously rejected by high courts. Mokatlal versus Kailash Chand is a notable case in the realm of property law in India. This case primarily revolves around the interpretation of Hindu Succession Act 1956, particularly focusing on the rights of daughters in the co-parcel property. So before we dwell into the specifics of the case, let's set the stage with some background information that would be required to understand this case. Now, to understand the case, we first need to grasp the concept of co-parcel property in Hindu law. Traditionally, a co-parcel consisted of a male member of a family, his sons, grandsons and great-grandsons, all of whom collectively held ownership over the ancestral property. In this setup, only male members had a right by birth in the co-parcel property. However, the Hindu Succession Act of 1956 introduced significant changes. This act aimed to codify and amend the law relating to intestate or unwilled succession among Hindus, ensuring that female heirs also had the right in property. Despite these changes, there were still ambiguities and limitations, especially concerning daughters' rights in co-parcel property. Enacted on June 17, 1956, the Act sought to amend and codify the law relating to intestate successions among Hindu. The Hindu Succession Amendment Act of 2005 further amended these provisions, giving daughters of the deceased equal rights with sons and subjecting them to same liabilities. This amendment marked a significant shift towards gender equality in property rights within Hindu families. Section 14, Subclause 1 of the Hindu Succession Act mandates that for a female to assert full ownership of an undivided HUF property, she must satisfy two criteria. First, she must be in possession of the property, and second, she must have acquired the said property through inheritance, device, partition, maintenance, gift, skill, exertion, purchase or prescription. Now, understanding these legal nuances is essential as we delve deeper into the specifics of the case at hand. So before we go there, we'll talk about certain landmark judgments that have come in this particular area before the current judgment. So in the case of M. Sivadasan through legal representatives versus A. Sudhamani through legal representatives and others, the case in 2003, the Supreme Court observed that the possession is a prerequisite for sustaining a claim under subsection 1 of section 14 of the Hindu Succession Act. The court stated that a Hindu female must not only possess the property but must have also acquired it through specific means such as inheritance, partition in lieu of maintenance or arrears of maintenance, gift, her own skill or exertion, purchase or prescription. On the other hand, in Chaudhary versus Ajudhya, the High Court of Himachal Pradesh held a different view. The High Court stated that it is immaterial how the female acquired the property. If she possesses any property, it is considered her absolute property. Now, these contrasting interpretations highlight the nuanced and sometimes conflicting perspectives on property possession and ownership rights under the Hindu Succession Act. Now, in the present case, the adopted son of the female who was a widow claimed partition over the suit property on the ground that his widowed mother acquired the HUF property by way of inheritance after her husband's death. The property originally belonged to Kishan Lal, whose son Mangi Lal and Madhu Lal inherited it. Madhu Lal died issueless in 1929 and survived by his widow Nand Kanwar Bai. Now, Nand Kanwar Bai claimed to have adopted Kailash Chand in 1959. Kanwar Lal, who was Mangi Lal's son, the other brother's son, executed a will in favor of Mukat Lal, who became the owner of the suit property upon Kanwar Lal's death in 1954. Nand Kanwar Bai filed a civil suit in 1958 for declaration of title and possession of the property, but it was dismissed in 1959. She was only recognized as having a right to maintenance from the property, but not ownership of the property. However, the Hindu female was not in the possession of the HUF and her suit for claiming title and possession over HUF was rejected. No appeal was allowed against the judgment and the decision became final. Despite this being the position, the adopted son of the Hindu widow filed a suit for partition of the HUF. Ultimately, the suit came to be allowed by the High Court against the High Court's decision. The Supreme Court was approached by the appellant. Now, in this particular judgment, the court opined that the essential ingredients of subsection 1 of section 14 of Hindu Succession Act 1956 is possession over the property. Since the deceased female widow was never in possession of the suit property, therefore she cannot claim ownership over the suit property as per Hindu Succession Act. On the point of whether the adopted son of the deceased female widow could claim right in the suit property by way of filing the partition suit, the court held that since the female deceased widow was never in possession of the suit property, therefore the suit for partition claiming absolute ownership under subsection 1 of section 14 of the Hindu Succession Act could not be maintained by her adopted son. The Supreme Court in this case concluded that since Nand Kanwar Bai never possessed the property in a manner that could convert her limited right to full ownership, her legal heir could not claim absolute ownership as well. The court set aside the previous judgments that were in favor of Kailash Chand and restored the decision that recognized only a right to maintenance. Now, this ruling highlights the crucial role of possession in establishing ownership claims under Hindu Succession Act, ensuring that both conditions of possession and legitimate acquisitions are met for female Hindu to assert full ownership of HUF property. This ruling also clarified the conditions under which a Hindu widow or her heirs could assert ownership under the Hindu Succession Act, stressing the necessity of possession combined with the manner of acquisition. This case is significant for its interpretation of subsection 1, section 14 of Hindu Succession Act, which affects the right of women in Hindu joint family properties. This was all from our side today. Thank you so much for watching. If you liked the video, please like it and share your thoughts and questions via the comment section, and share this video with like-minded people who would benefit from such information, and subscribe for more such knowledgeable content that is available for you. Thank you so much. See you soon.